proclamation of adherence to a text is not enough. Institutional development must be up to the task of applying it, and that is courts. Some of the largest countries in the world have signed the New York Convention but are incapable of demonstrating an acceptable record of judicial compliance with its terms. In a number of the largest countries of the world, the answer is zero when you ask, can you show me a single instance of a foreign award enforced in your country? Is the objective, therefore, to quell judicial tendencies to assert judicial dominance, or is it to protect national interests? Is this a zero-sum game where every successful assertion of arbitral jurisdiction is a victory and every instance of judicial predominance is to be deplored by us, the arbitration community? The answer is certainly negative. There is nothing inherently superior about the work of arbitrators. To the contrary, let me say this, to the contrary, in an ideal world, public justice would be of such a quality in terms of fairness, insight, and empathy that the allure of arbitration would vanish and arbitration wouldn't exist. That ideal is very remote, and arbitration does remain attractive both nationally and internationally. Yet arbitration unchecked inevitably means arbitration abused. A legal system where, let's say, 5% of challenged awards are rejected by the courts suggests what? I'd say maybe a healthy environment for arbitration, on the reasonable hypothesis that one case of arbitral misconduct in 20 instances of bad losers is not a bad scorecard for arbitrators. A 50% rate, on the other hand, suggests, on the assumption that available arbitrators are not egregiously inept, it suggests judicial intolerance. What is the balance? Ultimate freedom is not the goal. The test of an arbitration-friendly venue is not one where no arbitral decision is ever disturbed. That is rather suggestive of a degree of indifference, which will inevitably be susceptible to abuse. True, there are dysfunctional states where primitive forms of dispute resolution reign supreme, faute de mieux. And there are judiciaries unable to overcome a tradition of interference in everything that arbitrators do, and therefore deserve censure. Yet there is, I hope we all agree, there is such a thing as good annulments of awards. So before railing against interventionist judiciaries, one would do well to consider the perceptions of informed observers as to the caliber of arbitral performance. Whatever the quality of their understanding of the arbitral process, judges are naturally sensitive to a number of principles which should facilitate their interaction with arbitrators. There is, for example, broad agreement that an essential feature of human rights is the right to a fair trial. We should, however, be aware of the imposture of dictators and bureaucrats who turn this principle on its head, as though its objective is to bestow upon them an entitlement to impose on their justice to the exclusion of all others. This is in reality a project of entrenchment. It has nothing to do with the aspiration of affording acceptable justice to all. The social scientists have not, it seems, assessed this matter, but who among you would be surprised to find that the few countries which in fact succeed in delivering decent justice to their population at large, not just the elite, the few countries who succeed in delivering justice to all segments of their population, where deserving parties win in good time at no cost to the deserving party. Who would be surprised to find that those are precisely the countries who at the same time embrace arbitration. And that is food for thought. The essential objective is that of a fair trial. It is a matter of fundamental human right and the assigned objectives, as I said, of judges and arbitrators alike. Systems that deliver poor formal justice have no right to close the door to arbitration. Equally, when a form of arbitration proves defective, it has no title to claim immunity from state challenge or state control. Arbitrators have no greater entitlement to their office than do dictators or bureaucrats. Whether they're appointed by the state or chosen by the parties, decision makers have the duty to pursue the same objective, decent justice as a right of those who come before them. In a good legal culture, each is respectable and respected. Both have the same fundamental objective, and therefore, as is often said, but not often carried out in practice, ideally it is a partnership. I wish to conclude in a few moments by mentioning something which I consider to be the attraction of specialized courts. This is one way of going a bit further in exploring the proper interaction of arbitrators and courts and this partnership. We start with an observation. It is natural that arbitrators know more about arbitration than judges do, particularly in the international arena, where experienced arbitrators today are often well versed in the norms established by national laws and international treaties and the rules of important international institutions. That may not be the case with judges, who are responsible for a general docket and who only occasionally come across a dispute about arbitral jurisdiction or a foreign arbitral award, let alone a foreign arbitral award against the state, raising issues of immunity and the like. Therefore, perhaps it's not so surprising that judicial performance in applying the New York Convention has been, even in the most sophisticated jurisdictions, somewhat uneven. It is sometimes suggested that the cause may be in the admittedly imperfect text of the treaty, which reflects the infancy of modern commercial arbitration in 1958, and the inevitable compromises of such negotiated texts. Yet, it may not be the case that the answer is in revisions of the text. Even if we could all go back to 1958 and ameliorate the text with hindsight, it would be impossible, surely, to avoid some of the broad provisions, some of the broad wordings, which are capable of being used as loopholes, deal with topics that range from arbitrability to public policy. In an instrument which is intended for universal application, necessarily expressed with brevity, because otherwise prolixity itself would lead to inconsistent interpretation, it is unavoidable that some important provisions be worded in terms of generality. For the Convention to succeed, such terms must be applied in good faith. When it is tested in courts, the party seeking to rely on it is usually a foreigner. And the party that seeks to avoid its application, whether to repudiate arbitration, notwithstanding Article 2, or to escape enforcement under Articles 4 and 5, is usually a local party. Judges of first instance may be particularly susceptible to the pressure of local interests in individual cases, particularly when they have no experience with cases of an international dimension. Higher courts naturally tend to take a broader view, recognizing that individual cases have wider ramifications and that international treaties are meant to create mutual advantages in the aggregate and in the long term. So we have seen, and now it's interesting to look at this as sort of a global laboratory. We have seen examples of the emergence of specialized courts in the way that nation states organized, may I say so, their judicial administration faced with international problems in general and the enforcement of foreign arbitration agreements and awards in particular. Examples, in fact, abound. Some countries give you a wide range of different locales. Sweden and Indonesia have designated a single national jurisdiction. In one case, it's the Svea Court of Appeal, in other cases, the Central Java Court of Appeal, to have exclusive authority to deal with enforcement of awards rendered outside the national territory. The judges of those courts should structurally have an incentive to learn the arbitration process, to learn what the instruments are, to develop a consistent way of applying them. There are appellate courts, and there is a Supreme Court, so there is a fear of ultimate censure, and of course, with regard to treaties, the specter of diplomatic intervention if treaties are not enforced in the same way across borders. So the judges there in these specialized courts have that incentive. Here's another very interesting example, dealing with the specific problem of potential local resistance. This astonished me the first time I heard it, and if it's the first time for anybody here, I think you'll be very surprised. The People's Republic of China. China is a miracle. How can this country, so huge, hold itself together as a single state? It's not without problems. If you speak to any Chinese public official, they will mention that how to hold the center together and how to ensure that international instruments, whether treaties or contracts, are applied in the national interest down in some province 1,000 miles away is a constant nightmare for Chinese officials, and they work very hard at it, and the miracle is that China is still a country. That might explain why the Supreme Court of China, this is part of the legislative system of China. It comes from the Supreme Court, not in the form of jurisprudence, but in the form of a directive. So the People's Supreme Court of China has issued a directive that no court anywhere in China may refuse to enforce a foreign award without prior authorization of the Supreme Court.